Hi, I'm Jonathan Eshkeri, an English solicitor and Spanish abogado. I practice law in England and in Spain, with offices in London and in Tarragona, just south of Barcelona. In this video, I'll be talking about inheritance in Spain. You may have experience with dealing with the administration of the estate of someone who's died in your own country. You may have been a beneficiary of an estate, or perhaps you were the executor or the administrator of the estate. If so, you'll know that the process can be time-consuming and in certain respects complex, particularly in relation to inheritance tax. In any event, whatever your experience of such matters to date, you may have heard that dealing with the administration of a Spanish estate is even more time-consuming, complex and expensive than the same process would be at home. It stands to reason that if you're dealing with questions of law that straddle two countries at least, and the documentation to be prepared is in a language that you don't master, not to mention the difficulty of communicating with the authorities in a country the language of which you don't speak fluently, the process is going to be that much more confusing and difficult to see through without the assistance of an experienced specialist in the field. If, for example, you're the beneficiary of an estate with assets in Spain, you'll be in one of two situations. Either the deceased will have made a will, in which case you'll have been named in the will, or the deceased will not have made a will, in which case you'll be a close family member of the deceased. In this video, I'll talk you through the main aspects of handling the administration of a death estate when the deceased did make a will. We refer to someone who has left gifts in a will as a testator. I shall use the example of a British citizen from Birmingham who made a Spanish will in October 2015 and had been living in Alicante, Spain for 10 years when he died in December 2015. When he died, he owned a house and a car in Alicante and had some money in bank accounts there. These assets are now called the Spanish estate assets. He left half of his Spanish estate to his 3 children in equal shares and the other half to a major UK charity. The Spanish will was valid upon his death and contained a clause stating that English law was to apply to the testator's estate. In August 2015, a European regulation came into effect which in essence determines that if you don't choose the law that is to apply to your estate when you die, the applicable law will be the law of the country in which you are habitually resident. If Spanish law is the applicable law, then forced heirship rules will apply. The detail and effect of these rules will depend upon the autonomous community in which the greater part of the Spanish estate assets are situated. That means that certain members of your family will have a right to a part of your estate, whoever may be the named beneficiaries. However, if you are not a Spanish national, and according to the law of your country of nationality you have what we call freedom of testamentary disposition, you can state in your will that you want the succession law of that country to apply, in which case you'll be able to leave your Spanish assets to whomever you wish. In England and Wales, we have freedom of testamentary disposition, which is why the testator in my example had the freedom to leave half of his estate to a UK charity. There is always the risk that a family member may challenge the will itself, but there is absolutely nothing that you can do about that unless and until it happens. In my example, the 3 children of the deceased and the UK charity will want to take the necessary steps to be able to realise the estate assets. That is, to receive in the currency of their choice the value of the part of the estate corresponding to their share. The way to achieve that is by accepting the inheritance. Unlike the position according to English law, where upon the death of the testator, the legal interest in the estate assets vests in the executor and the beneficial interest vests in the beneficiaries, according to Spanish law, the beneficiaries do not have any rights of ownership until they accept the inheritance. The acceptance of inheritance document identifies the beneficiaries, or the people acting on their behalf, and it identifies the assets to be inherited and the proportion in which the assets are to be inherited by the beneficiaries. It's open to the beneficiaries not to accept the inheritance or to renounce the inheritance. They may do that where, for example, the testator died owing a lot of money to third parties. The beneficiaries will inherit any debts of which they are aware and perhaps some of which they are unaware at the time, depending upon the circumstances and the way in which the estate is administered. So it simply may not make sense to accept the inheritance at all, which is a decision that the beneficiaries will need to take. Once the acceptance of inheritance has been signed, any inheritance tax payable will be paid, and the property in Alicante will be transferred into the names of the beneficiaries. In my example, half of the property will be registered in the name of the UK charity, and 1/6 of the property will be registered in the name of each of the 3 children. The funds in the bank accounts will be divided between the beneficiaries in the same proportions. The car will be sold and the proceeds of sale distributed in the same way. If you'd like advice and assistance with administering a Spanish estate, or if you have any queries that this video message hasn't answered, please do be in touch with me by email or by telephone. The information can be found on our website, www.solicitorsInspain.com. Thanks for watching.